Good morning to all the students. My name is Gawi George, and I'm taking you this morning on labor and employment law. That's what we're looking at this day. And first, we're looking at history and source of labor law in Nigeria. So, the history and source of labor in Nigeria law may be divided into legal and extra legal sources, and also extra legal sources in contradictions to the legal source are those are created by the voluntary conduct of the parties. Then we looking at the legal source of Nigeria labor law are one, the Nigerian Constitution, two, the Nigeria Statutes, three, and we're looking at the received English law comprising the common law, the doctrines of equity, and the statutes of general application in form in England on January 1st, 1990. And also, we're looking at the Nigerian case law, that is decision of Nigeria court relevance to labor law, and the extra labor sources on the other hand, including the collective agreement, and we're also looking at the workplace notice and documents, also rule books and handbooks, and also customs and practice. That's what we're looking at. And so we're looking at history of the Nigerian law in Nigeria. The labor law in Nigeria is generally defined as the branch of a country's law which regulates industrial relation. In essence, labor law are also meant to guarantee peace and also harmony in the industry so as to increase productivity and profit. Our labor law are also largely a reflection of our colonial heritage. By the virtues of these many principles of British law, labor law features prominent in our also labor status. So the main characteristics of the inclusions of colonial masters were the introduction of labor law and policies which also seem largely designed to facilitate the commercial and economic objectives and interests of the colonial masters. Thus, in spite of the fact that Britain proudly claimed to observe the Bills of Rights and rules of law, labor leaders were also targets of representation and also oppression for no other justifiable reason than they that effectively to also demand for their rights. So in 1861, Lagos was co-ceded to the British Crown, and in 1862, it was made a colony or settlement, as if was something called by virtues of the Supreme Court ordinance. So 1876, also English common law doctrines of equity and the status of a general application were received into Nigeria legal also system, and by extension also the Nigeria law. Then, notwithstanding that the offense of a criminal conspiracy as it is affecting trade union had also been abolished in England by the Conspiracy and Protection of a Property Act as far back as 1875. Nigerian workers did not enjoy such protection until 1939, when the trade union ordinance was also enacted. So apart from the status and laws also regulating employment, common law has also played and also continues to play an important, if not dominant, role in regulating the relationship of the masters and servant, or as it is known in modern times, and also employers and also the employee. The courts have by themselves also developed rules which have become permanent features of the contract of employment. By these rules, certain obligations and rights are implied into contracts of employment in order to give such contract the required and also necessary business efficacy. According to the eminent professor of law, Professor uh, Viagara, Nigerian judge provide the vehicle by which they receive English common law is also brought into Nigerian law with hidden effect. So the learning author cited the Supreme Court judgment in Ezeni versus in JDK 1965 and the National NMIR 95 as an example of the distinctive character which the Nigerian judicial divisions are also taking on the light of the prevailing unfavorable local also circumstances. So labor law in Nigeria has come to stay and has also grown considerably well after its first introduction following the cession of Lagos to the British Crown in 1861 and has also enjoyed a high level of judicial activities up to date. It is now part and parcel of our law with up to date legislation which take care of as they emerge. Now, looking at the purpose of the labor law, the one of the major purpose of labor law is to regulate the relationship between an employer and employee. By this, the common law and state and statutes have also established that an employer is under an obligation to ensure the safety and security of his employee. Therefore, it is now recognized that an employee owe a duty to each employee to take also such action as the nature of the work and also circumstances of the employee demand so that the employee is also reasonably safe at the workplace. And also an often quote statement of these important duties of employee is that of Lord Wright in Wilson and Clyde Co. Company Limited, English, 1938, as Act of 87 at 80, where he said that the whole cause of authority consists also recognizes a duty which rests on the employer and also which is personal to the employer to take reasonable care for the safety of his workman, whether the employer is an individual, a firm, or a company, and whether or not the employer takes any share in the conduct of the operation. Therefore, the uh, the primary purpose of labor law is that it imposes direct liability on the employer and also separates from the master's vicarious liabilities for negligence of a servant. This is a duty imposed on the masters and uh, also recognized by the common law. It is also popularly referred to as the duty of care, but it is subject to certain limitation as it's open to defense of uh, voluntary non-fit injury and also contributory negligence. This duty is now also statutory under the Factories Act and other statutes also designed for the safety of the workers. And we're looking at the scope of labor law. The understanding the major scope of labor law, one has to look at the like and the probable legal consequence which may follow it in a situation where there is a breach of any of the obligation imputed on either the employee or the employer or employee. A typical example of this scenario being examined is wrongfully dismissal of an employee by the employer without the recourse to the regulations and also the guidelines of the company. This, under the law, is a typical example of wrongful dismissal. This will also automatically give rise to a civil proceeding at the instance of the wrongful dismissed employee. So, on the other hand, there where an employee who is under an obligation to give adequate and subsequent notice to the employer before quitting such job abandons his employers without recourse to the also the conditions of his employment. He will be the defendant at the suit of the company stroke employee for damages or the cause as a result of his unprofessional attitude to work without resource to the regulation and also condition of his employee. And we are also looking at the legal sources. We're looking at the legal sources. We're looking at the Nigerian Constitution. We're looking at the Nigerian legislation, and we're looking at the record receipt law. We've talked about that also, and we are moving on now, and we are looking at the concept of employment. The concept of employment. The contract of employment is the central element in structure of labor law. At common law, the assumption is that the terms of the contract are also freely established by parties who are equal. Also, contract of employment, otherwise called the contract of service, like all other contracts, is governed by the general law of contract. So, therefore, all the essential features which also characterize ordinary contract must be present in the contract of employment before it can be valid contract of service. So the major object of a contract of employment is to put a written form and also regulatory guidelines for the labor relationship between the employers and the employees. So the this unit also meant to emphasize on all that also. And so we're looking at the objective, and we're looking at what is a contract of employment. As in every form of contract, the contract of employment is also central element in the structure of labor law. And once also could also succinctly say that a contract of employment is that written document that governs the relationship between an employer and an employee. So this will also generally presuppose that there is also someone who is in their need of labor, and also another who is also their need of wages. So the nature, we are looking at the nature and the basic element of contract of employee. As stated in the introductory part of this unit, a contract of employment, like all other contracts, is governed by the general law of contract. Therefore, all the essential features which characterize ordinary contract must be present in a contract of employment before it can be said to be a valid contract of employment of service. A contract of employment may be also under seal or in written or also infer from the conduct of the parties thereto. And then the essential element required for the valid is contract is one, the offer. There must be an offer from the offeree to the offeror, and then the offeree must be able to accept the offer, and two, there must be an acceptance. The person giving the offer must accept the offer, and the offer given. And once the offer is given, then it's now the work of the offeree to accept the offeror's contract, or he rejects the contract. So the 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 labor law, however, there is also a clear distinction between servants who are subject to the whims and also comprise of the masters who also choose, direct, or monitor, control the servant in respect of jobs to be performed by the servant. Then with the second one we are looking at the acceptance. When there's an offer, it's now a willingness to contract, and acceptance on the other hand is a final and also an equal expression of access to the terms of the offer that's given by the offeree, and also they have to accept it, one party or the two party. Then consideration. Consideration takes the form of promises exchanged by contractual parties, or the duty undertaken by one party on account of the promise of other. And when we talk about consideration, we are talking about ability. The valuable consideration in the eyes of the law may also consist either in some right, interest, profit, or benefit accrued to one party, or also the furtherance, the determined, the detriment, and also loss to responsibility giver, suffer also undertaken by others. So acceptance must be in form, consideration must be in form of money or his wages, or consideration for wages is at work. Then there must be intention to also create legal relationship. The intention we're talking about is that the parties intend that legal consequence should flow from their agreement. So intention also answer is negative. There's no contract. So if there's no intention, the contract remain void, and now and it cannot work. And so there is an element, we see element of when it's coming to consideration, we're looking at elements which include illegality, and we're looking at lack of a capacity to contract. When we talk about illegality, that means if one of them should reject it, then it's no more considerable, or has ability to take it. Then two, if legal lack of capacity to contract, if it doesn't have what it takes to do the contract, that means the contract is going to fail. Then we also look at misrepresentation, when the person mean one of the parties mean one thing and the other party means another thing, and they couldn't really come to a compromise, and somehow there's a misrepresentation, and then mistakes to in this contract. If there are mistake, then there should be a correction. Then we also look at duress and also undue influence. When we talk about duress and undue influence, we are talking about that the person doesn't really want to do it, but is forced to do it. So all these have to be taken care. Then looking at counter capacity to contract, I've explained that some part of it, that there must be a capacity to the contract, and the person must be ready. The head form part of this basic element that may also vital the contract of employee is to create legal relation, and it's worth to mention that it's also a basic requirement for a valid contract. So there must be a capacity, the person must have the power and to do it. Then similarly, interpretation of ongoing, also that apart from men and women of food age, infant, insane, and drunkard person generally lack the contractual capacity to a contract. Then we're also looking at the certainty. For a contract of a service to be valid, it must be certain, or in its terms. The parties must be certain, or must be capable of being reasonable, identified. Then the subject matter must be certain, and also essential term must equal be certain. Then we say legality. The proposed also contract must be a legal, also in must be legal in the object and manner of performance. As an example, a contract would also, which involves the commission of a crime, commission of crime, for example, smuggling or employment of people for the purpose of sexual immorality, will be also null and void. So also a contract also intends to defraud the tax also authority, say by understanding the salary so as to pay less tax. All this needs to be considered. And we're moving on to the application of the status to contract of employment. The Labor Act 198, Laws of the Federation of Nigeria 1990, is the only Nigerian statute which make provision on minimum terms, which also certain employee and also contract must have. The parties to the contract of employee also covered by the act also can agreed on terms are better also than those of the Act. And however, it is not a disputable fact that where a contract of employment is covered by the set by the Act in absence of contrary terms agreed by the parties, the term also provided by the Act will also form part of their contract. The term will include the following: one, period of notice. That is section 11 subsection 1 Labor Act. Then two, the provision also of transport. That's section 14 subsection 1 Labor Act. Then duty to provide work, section 17 Labor Act. And also looking at annual holiday with pay, section 18 subsection 1 Labor Act. In the same vein, by the virtues of section 2 subsection 3 of the Trade Dispute Act, cap 423, and also 18 subsection 3 of the Wages Board and also Industrial Council Act, cap 466, terms of the collective agreements to which section also relate become part of the contract of employment of employee also concerned once the Minister of Labor makes an oral or the effective. So we also are moving on to the terms of the contract of employment. By virtues of Section 91 of the Labor Act, Cap 196, laws of the Federation of Nigeria, a contract of employment means any agreement, whether oral, written, or expressed or implied, whereby one person agrees to employ another as a worker and that other person agrees to serve the employer as a worker. By the foregoing, it is also clear that contractual terms consist of express and implied terms. So express terms comprise those oral agreements agreed or reduced to writing. Section 7 of the Labor Act makes it mandatory for an employer not later than 3 months after the commencement of a worker employment to take the participant particulars of the employer, place and date of a commencement of the agreement, and the nature of the employment, the duration of the contract. So, method of termination of a contract, wages, and also the period of payment, hours of also work, also holiday and holiday pay, and also the sick pay. So, it should be considered. And implied terms are also those which the contract parties have not expressed or made but were, which may yet form a part of their contract. Such sources of the implied term include common law, A, common law, B, collective agreement. There must be a collective agreement between the employee and the employer. Then workplace notice and also document. The D, customs and practice, and E, the terms also imposed or also assumed by the court. Then the statutes. Now, all these need to be considered before some contracts are made. We move on to who is an employee. It's a great question, and we're looking at who is an employee. And according to definition by previous provided by Labor Act, a worker means any person who has also entered into a work under a contract with an employer, whether the contract is for manual labor or clerical work or is express. So implied or written, and whether it is also contract, also personnel by to execute any work or labor. So the foregoing also include all other or sort of contract which shall be also examined later. We move lately. We have the objectives. Then, who is an employer is the question here. And we say the contract of an employer deals with the relationship between an employer, and employee. So the contract, which is also called a contract of service, is marked by different from a contract for also services, and under which an independent contractor is engaged. So the contract of employment is the basis of the labor law, and for the following reason, the courts have had to distinguish between employees and independent contractors. So, number one, at common law, an employee is also vicariously liable for the civil wrongs that is thought of the employee, but not generally for those of the independent contract. Then, two, we say that although an employee owes its common law and under statutes a general duty of care to lawful visitors to his premises, he owes his employee at common law a personal duty of care, that is a duty to take also reasonable care for the safety of his employee in the course of their employment. In the course of their employment. Three, income tax is also deducted by employment employer under the pay as you earn and system from the wages or the salary of an employee. Then independent also contract or self-employed also person pay their tax under a different method. So statutes such as the Labor Act Cap 198 with the Compensation Act and Cap 470 afford legislative protection to certain class of employee, which do not apply to independent contractor. Five, the implied rights and duties of contract of employment do not also apply to contract for service. Then six, under the Companies and Allied Matters Act, also Cap 59, Law of the Federation of Nigeria 1990, Section 494, provide that employees have also certain preferential rights over other creditor of the employee or employer in the or even of bankruptcy and winding up of the company. And so we have been able to see that. And employee also therefore is that person who is employed by another, the employer who determine his wages, salary, times of worker, and work and kind of work to be done in an organization. And so we're moving on to the contract of service. And under the contract of service and contract for service, it has also always been opinion of several legal rights that it's essential to remember that the protection offered by the labor status is only for those under a contract of service, commonly referred to as employment, and employees, and not those under a contract for service, often described as independent contract or self-employed person. This distinction is more than a question of mere uh, uh, semantics in order to also determine whether a person is a servant or an independent contractor. Also, various tests has been also applied, and then we're looking at the control test. The usual view is that the sole administrator of whether a contract of service exists between A and B was the exact extent or degree of control which B was entitled to also exercise A in the letters performance of his contractual obligation. And so we can see the case of Collins versus Hart County Council, where the distinction between a contract for service and a contract of service can be summed in the way, in one case, the master can order or require what is to be done, while in other case they cannot only order or require what is to be done, but how it shall be also done. In other words, we say that in other words, we say a person is an independent contractor if the employee can only tell him what he wants him to do, but not how he should do it. On the other hand, a person is an employee if the employer tells him not only what he should do, but that he also should do it. So the contract of service or the test of a control had four also indices. These four indices will continue in our next class. We're looking at the four indices, namely, which we'll do in the other classes.